Hello everyone, this is Tom Fox and I'd like to welcome you to episode 27 of This Week in FCPA for the week ending October 21st, 2016, the Walla Walla Edition. I'm Tom Fox, I'm the Compliance Ambassador for the Red Flag Group. As always, I'm joined by my cohort, Mr. Translations, Jay Rosen. In this episode, we take on several topics. The first, the Lennox International self-reporting to the Department of Justice of a $475 bribe. Second, we have yet another guilty plea in the FIFA Corruption scandal. This brings us up to 17 guilty pleas. We talk about the public citizen letter to the Department of Justice and Securities and Exchange Commission regarding the Wal-Mart investigation. We take a little bit of a deep dive into the Miller and Chevalier Autumn 2016 FCPA report. We talk about the first FCPA Mock Trial Institute, which will be held in Houston on November 16th and 17th. We take a look at the upcoming FCPA blog New York City conference, and I preview my panel presentation with Mike Schur, moderated by Julie DeMarno, and Jay gives us a preview of the Jay Rosen Weekend Report. This is Tom Fox. I'd like to thank you very much for listening to This Week in FCPA. Hello, everyone. This is Tom Fox. I'm the Compliance Ambassador for the Red Flag Group, and I am joined, as always, by Mr. Translations, Jay Rosen, for This Week in FCPA for the week ending October 21st, 2016, the Walla Walla Edition. Jay, welcome.
Thanks, Tom. I'll tell everyone why you're going to Walla Walla.
Walla Walla is the home of Whitman College, which is where my daughter attends, and I'm going for Parents Weekend.
How excellent. I do not get to go to Walla Walla this weekend, but I'm sure you'll tell us all about it next weekend.
No, but you'll get to go to Parents Weekend with two girls in college rather than one, so it'll be double the fun. Look forward to it. So, Jay, we had actually a pretty interesting week in the FCPA. I wondered early on what might come up, but a few things shook out. So why don't we jump right into it? We had a rather amazing report of a self-disclosure, and that was Lennox International. It's a Texas-based company, filed a 10K, which said, and it's just too special, I have to quote. In October 2016, the company self-reported to the Securities and Exchange Commission and Department of Justice an alleged payment of 30,000 rubles, wait for it, approximately $475 to a Russian customs broker or official. The company, under the oversight of its audit committee, has initiated an investigation into this matter with the assistance of external legal counsel and external forensic accountants. So, Jay, we have our first notice of a self-disclosure where a one-time bribe was paid of $475. $475. So, what do you make of that?
I make of that it's probably less than half the hour of whatever forensics company billed them for 1 hour just to do the investigation. I think it's pretty much a head scratcher.
Yeah, maybe we can talk about that one a little bit and maybe move on to the next item of note this week. We had another guilty plea in the FIFA corruption case. This was not an FCPA case because FIFA is not covered by the FCPA, but the former president of the Costa Rican Soccer Federation, a member-elect of the FIFA Executive Committee, and the head of CONCACAF, a member of the CONCACAF Executive Committee, a gentleman named Eduardo Lee, pled guilty to racketeering, wire fraud, and wire fraud conspiracy. That's racketeering conspiracy. He took bribes for contracts for the media and marketing rights to FIFA qualifier matches and for Costa Rican national teams. He also agreed to take a bribe for a contract for uniforms for the Costa Rican national team. He embezzled over $90,000 from FIFA that was designed to be sent to the under 17 Women's World Cup soccer tournament, and he used diverted money using various bogus invoices. So he makes number 17 of corrupt officials from FIFA to plead guilty. And I guess the takeaway from this, other than just the continuing slime and ooze of FIFA corruption, Jay, is that in the sports marketing and sports team arena, if I can mix my metaphors, there's a variety of high-risk transactions. And when you have a national soccer team, it may be government-run or state-owned enterprise under the definition under the FCPA. And really any marketing efforts to those companies, whether they be media rights, whether they be marketing of tournaments and games, whether it be clothing, whether it be shoes, whether it be a plethora of other rights or services or goods that a national soccer team might use, that could be a high-risk transaction subject to the FCPA. So once again, yet another FIFA official found guilty. Last week, at the end of last week, we had a letter sent, Jay, by the public interest group Public Citizen, and it was sent jointly to Attorney General Loretta Lynch and to SEC Chairperson Mary Jo White, and it was around the Wal-Mart FCPA investigation. It's not yet an enforcement action. And they go through some of the facts of the case, at least as reported by the New York Times, and they end with the following statement. A settlement with Wal-Mart should be measured against three criteria. Number one, does the settlement disclose what the government found? In contrast to recent settlements with civil settlements with large banks, the settlement should provide a detailed description of the facts of Wal-Mart's wrongdoing as determined by the government investigators. Two, does Wal-Mart admit to its wrongdoing? If the facts reported by the New York Times are found to be correct or roughly so, or if a global pattern of misconduct is found, then what occurred is neither an accident or oversight. Wal-Mart should be required to acknowledge the wrongdoing. And three, is the penalty sufficient to achieve deterrence? Reports of relatively large sums sought by the federal government from Wal-Mart suggest it aims to disgorge Wal-Mart's wrongful, ill-gotten gains as a result of the alleged bribery. Mere disgorgement, however, is likely to under-deter future wrongdoing, or as other companies may rationally calculate, it is worth violating the law. So I guess, Jay, it was really these criteria that were listed in the letter that caught my interest because it gives us, I think, a framework to discuss what is the purpose of enforcement. Is it punishment? Is it remediation? Is it to prevent recalcitrance? Is it to prevent recidivism? What is or should be included in any resolution documents? Should they be a negotiated settlement between the parties if the settlement is indeed negotiated? Or should the government simply write up the facts as they see them? And then what's the role, really, of the government in all of this? And this moves to the question of, are they there simply to deter, or are they there simply, additionally, to help companies comply with the law? So I guess I was intrigued by those questions posed in the terms of the criteria they set out. So perhaps we can talk a little bit more about that. Go ahead.
Sorry, where does Mr. Weissman get his standing? Do you know much about his background in Public Citizen?
I do not. I do not know Mr. Weissman. Now, we're not talking about Andrew Weissman at the Department of Justice. We're talking about Robert Weissman, the president of Public Citizen and the author of the letter that went out.
Yeah.
So, Jay, one of the things that you talk about as a great resource throughout the year is the Miller and Chevalier FCPA report. They are issued quarterly and then have an annual edition, but they just come out with their 2016 autumn report. And I was wondering if you saw anything in it that really struck you on this occasion, or anything you wanted to raise for our listeners.
Well, we finally, after, I guess, the last 5 years, really seem to see enforcements go up on the rise. And there is a great chart here. And thus far in this year, in 2016, there's been a total of 37 enforcement actions. And the way that breaks down is there's been 25 of them that were SEC corporate resolutions. And then there was the remainder, 12 of them, that's 37. So if you look at the high water mark of 2010, when there were combined 72 enforcement actions, we are now half the way there through 3/4 of the year. And so, they're suggesting that some of this is that they're breaking down a lot more of these matters. The SEC are handling corporate resolutions, and the DOJ is dealing more traditionally like they do with misconduct. There's been a new wrinkle that there's been 2 matters that were just concluded by the DOJ that although they had declinations, they were declinations with disgorgements. So, you've got the raw numbers on the rise, and then you've got the fact that, we're still looking at many of the same hot geographies that we've looked at before. China has a disproportionate number of enforcement actions, but we also have Latin America, Africa, Russia, and India. So we can still be pretty positive that if your company is doing business in the BRICS, Brazil, Russia, India, and China, and you do not have a very robust ethics and compliance program and a code of conduct, and I wouldn't be Mr. Translations without saying that those source materials, if they're in English, should definitely be translated into the local language where you do business. So I guess what will remain to be seen at the end of the year is how much of this stuff was driven by the new pilot program, and how this is just going to augur for going forward into the next year. We've had a couple of our companies jump up into the top 10. So coming in at number 4 is Oxif. Are they a hedge fund or they're private equity?
Yes.
Yes, okay. So they come in at $412 million. It's a combination of fines and also disgorgement. And then coming in at number 7, one of your favorites that we spoke about 2-3 months ago, VimpelCom came in at $398 million. So, and then when we look at the total declinations this year, 2 of them were SEC, 13 of them were DOJ, and as I said before, 2 of those DOJs were with disgorgement. So it's a report that's jam-packed with facts and figures, and then they also kind of take through a lot of the key cases that we've been speaking about since the beginning of the summer: Johnson Controls, Key Energies, AstraZeneca, GSK. So it's a great report. You will include it with the show notes. But I think Miller Chevalier does this kind of off season that they tend to do the autumn report all by themselves. So this is really gives the practitioner a time to kind of dig in and not worry about competing facts and figures. And this is a real good snapshot of where we've been for the last month, and it might be a roadmap of where we're going to continue to go through the rest of this calendar year and into the next.
And you really hit on the one thing that highlights it for me, or makes it so valuable for me, Jay, is that it's a snapshot of where we are through the year. It focuses on the last quarter, and it summarizes everything. So it gives you a really good sense of yearly trends to date. And we have both seen just an explosion of enforcement actions this year. And, the 11 we had in the month of February alone, leading up to the pilot program announced in April, and the increase in announcements of enforcement actions in the end of Q2 and into Q3, which comprise the autumn report here, give us a real sense that things are really speeding up. I don't think you can chalk up the summer enforcement actions to the pilot program alone, since it wasn't announced until April. All of those settlements were already in the works. Some of the cases were relatively new, having been self-disclosed the previous year to the Department of Justice and SEC, but some of those cases were 5 years old. And certainly OCZIF had been around since 2011. So it's sometimes hard to predict when cases are going to settle out, but we've certainly had quite a few settle this past quarter. Although after last night, we may not have a change in administration in this year's election. I think that this Department of Justice will move towards resolving cases before a new administration comes in. I don't think we're going to change parties now, but after last night's debate. But when you have the closeout of an administration, the agency and the Department of Justice works to close out as many cases as they can. So we may have another big push here in upcoming Q4, Jay. So I just have to give a shout out to our friends at Miller. They really do a great job on this report. I'm not sure we mentioned the cost, but we should, because it's free. And that's why we're going to link to it in the show notes. And I hope that you will download it, take a look at it. You can get their prior reports. They've got contact information if you have to, or if you'd like to follow up with any of the people involved in the report. Obviously, Matt Ellis is a good friend of both Fires and this podcast, and Matt's a big part of the Miller team and so focusing on South America. But a great resource, once again, solid information that both of us and all of our listeners can utilize going forward. So kudos to Miller.
And two more minor points I just wanted to make. In terms of talking about the pilot program, while it may not be the inciting event that caused these resolutions, I think its introduction is important because it's a mechanism that allowed some of these long-standing cases to be resolved in a favorable manner. So I think, to your point, when we get to next April and we look at the whole year of the pilot program, then we will only at that point be able to look at its efficacy. But I think that's still an interesting thing about how we can use the pilot program now as a mechanism to resolve. The other thing I would point out is when you get a chance to download this report, in the past, DOJ really used to kind of take the lead on these things, and I think it's also interesting now that you're seeing that when you look at these trends here now, SEC is almost doubling up what DOJ's done. So I think DOJ is trying to concentrate on finding those individual cases that they can make, and in the past they may have had some missteps. So hopefully, they'll be working on something that we see at the beginning of next year when the parties do not change, because Tom Fox said it here first.
So you raise a really interesting point, your former point, Jay, the first point, which is that even if these cases certainly came into the pipeline before the pilot program was announced, the pilot program provided a mechanism for, in many cases, I think in all cases, a very favorable resolution to the company for extensive cooperation and extensive remediation. So that's a great point, that even if the pilot program was not in force or applicable when the cases came in, and for indeed some period of time, the pilot program has provided the structure by which very favorable settlements have been made with several companies over the summer, and you named those. So a really interesting point, and you might want to explore that on a weekend report, if I could suggest that to you. So Jay, we've got two events that I'm participating in that I wanted to highlight for our listeners. We have spoke about them before, but I think they're certainly worth mentioning again. The first one is next week in New York City on Wednesday. It's the first annual FCPA Blog New York City Conference. And Jay is attending, and I am participating in it. It's going to be a great conference. If you're in New York or surrounding area, I hope that you'll consider attending. It's run by Dick Casson and the FCPA blog. Many of us who are on the editorial board are going to be participating in the event. If you listen to this podcast, you're eligible for a 20% discount, and I'm going to have that link to both the conference and the discount in my show notes. The second thing is, and I want to once again give a shout out to the first annual FCPA Mock Trial Institute. Keith Hennessy and Joel Androphy, two lawyers in Houston, dreamed up this absolutely brilliant idea to put on a mock trial and have a deep dive breakdown of it. It's a 2-day event. I interviewed them for my podcast, which went up today. And in that podcast, Keith Hennessy really explained why he wanted to do it. Keith is an in-house practitioner. We worked together at Halliburton, then he went over to be the Chief Compliance Officer at NOV. And Keith really articulates that he thinks companies need to put the Department of Justice and Securities and Exchange Commission to proof, to their burdens of proof in trial. And he advocates corporations make informed decisions to go to trial when appropriate. Joel is in the really unique position of actually having defended an FCPA case, the individual John O'Shea, and Joel and his partner Sarah Frazier got Mr. O'Shea off with a directed verdict. So Joel has gone to trial against the government, and they put together a really interesting argument that companies need to go to trial. And to take Keith's point a step further, he would like to see companies go to trial to have the FCPA actually fleshed out from the judicial perspective. So check out my podcast. I think it was episode 287, where I interview them both for the mock trial. I've got the information on registration, also be in the show notes. Jay, have you been able to think about or maybe give us a sneak peek at the Jay Rosen weekend report?
Yeah, I'm going to kind of, as I said last week, I'm going to continue on. I actually prepped some of this stuff, and I have a 6-part series, and what we're going to look at this week is called How to Combine Human Translation with Machine Translation. And, where we're going to specifically look at that is more on the investigative side. And one thing that United Group just came out with is a new tool that we think will really help our clients, and it's called Octave MT for machine translation. And the way we envision this is, say you get a report in some foreign language to your hotline. You don't know what it says. You want to get a quick read on it, but you don't want to put it in a commercially available machine translation tool, because you will be leaving a copy of that somewhere out in the internet. So this allows you to get a quick read on something, to get a very quick gist, a translation that will take 2 or 3 seconds. It'll be behind your firewall, and then at that point you'll be allowed to make a decision: do I escalate? Do I remediate? So in the in the spirit of the introduction of this new tool, I thought I would kind of write about MT, machine translation, and where that plays a role in the investigative process.
Well, that sounds really interesting, and I'm really looking forward to it. I greatly enjoyed your part 1, so I didn't fully appreciate it was a 6-part series. So I think that this will be a great series for the compliance practitioner, but really, Jay, any company that has multinational operations could use such a great resource.
Cool. And Tom, besides your trip to Walla Walla, did you want to talk a little bit more about the panel that Julie DeMauro is hosting with you and Mike Scher, or do you think we're good on that?
Sure. Mike and I are going to talk about who does the Chief Compliance Officer report to. And I don't mean strictly in the corporate sense of who's your direct line and dotted line reporting. I mean, who are the constituents that you have to not only report to, but be accountable to? So clearly your boss, whether that's the CEO, whether that's the audit committee, whether that's the full board, whether that's the general counsel, you're responsible to that person. But as a chief compliance officer, you're also responsible to other constituents. Those constituents can be the board of directors, it can be the shareholders, it can be your customer base, it can be the regulators. If you take the position that part of the regulatory scheme is to work together with regulators to come up with the best, most effective compliance programs, particularly now with the hiring of Wei Chin. So Mike and I are going to use the prism of the Wells Fargo case to explore some of these points. Julie Demaro, great friend of ours, also on the editorial board of the FCPA blog, will be moderating us. If you've never seen Julie, she is an incredibly dynamic woman and will lead us through some really interesting questions. So Mike's got a lot to say on this. He's written extensively on Wells Fargo, as have I. And one thing we've learned, even as of today, Jay, there were reports of criminal investigations at the bank based upon some of the conduct that we saw reported. So it's continually evolving. It's a huge mess, but it's going to provide a lot of lessons learned. So we're going to try to use that Wells Fargo prism to talk about some of these broader issues at the FCPA blog NYC conference.
Great. Well, I'm looking forward to seeing you. And like we've said, this is the first of what we hope to be an annual event. And, you know, sometimes when you really have a laser focus, like a one-day event, you know, you can really drill down a bit more, and there really seems to be a real thoughtfulness and purpose of the panels that are put together. So I'm really looking forward to learning a lot next week in New York City.
Well, Jay, looks like we're at the end of our time, so I want to thank you and thank everyone for listening to This Week in FCPA.
Thanks a lot, and enjoy the podcast.